Let's start talking about wills. A will is a legal document that disposes of the testator's property after death. It can be revoked or amended or altered at any time up until the testator's death. By having a will, a testator can do a number of things. They ensure that the assets are distributed the way they wish. If they have minor children, here's where guardians are provided. And if this doesn't happen, if this isn't done, courts are going to appoint a guardian, and that may not be the person that the court or the testator wants as the guardian of their minor children. So minor children, if you have minor children and you don't have a will, this is probably one of the big considerations. And courts certainly want some sort of identification of what the wishes are of the parents, because they believe that the parents are the ones that are in the best position to make that kind of decision for their children. Another benefit to having a will, they get to select a personal representative to oversee the estate, the executor, right? If they don't, as I said, the court is going to appoint someone who will be the administrator. Saves money. Those who die without a will, they'll leave behind lots of legal issues for lawyers to resolve, and that costs even more money. That doesn't really need to happen if the testator makes arrangements ahead of time. A properly drafted will, as I've said already, can reduce the estate tax bill. So all of these are beneficial to having a will. Types of gifts that are found in a will. We have a gift that is specific. We can have general gifts, and then we have what I call the catch-all residuary gift. So let's go through these. A specific gift is basically what it says. It's a gift that's identified from the rest of the estate. So if I leave my house at 123 Main Street to X, right, that would be a specific gift. You can identify the house that's at 123 Main Street. I leave my classic 1964 Ford Mustang to X. That also would be a specific gift that can be removed out of the estate and given to X. A general gift could be in the form of a bequest of personal property or devise of real property. It doesn't really single out an actual piece of property like the specific gift does. So I could say I leave $15,000 to my nephew. I don't say out of what bank account or where's it going to come from. It's going to come from somewhere in the estate. It's a general gift. This other example is from the book. If someone owns 5 diamonds, they're all different sizes, and the gift to X is 2 diamonds worth $10,000. 2 of the 5 diamonds that value $10,000 are going to go to that X or niece, as I have in the example. There isn't one specific diamond that's chosen for the niece, or 2 diamonds that are chosen for the niece. It is general in nature. And then finally, the catch-all, the residuary gift. This is generally a clause in a will that says after all the debts are paid and the assets that have been specifically gifted are distributed, anything that's left over is given to B, right? They kind of get the leftover. Nothing that was already provided for. Just whatever's left is going to go to this particular person. So up next, we're going to talk about what are the formalities or the requirements of a will.